Hello, I'm Jason Sullivan of the Rathbone Group, and in this video of On Subrogation, we're going to talk about relevant evidence under the Federal Rules of Evidence. On Subrogation is your video resource to help you with any of the subrogation issues you may find as you're pursuing claims. Now, the Federal Rules of Evidence were passed by Congress in the United States in 1975. These rules apply to cases heard in federal court. Many states have adopted the rules without modification or with only some slight variances. It's important to know if you're in state court, the state rules may be different than what is discussed here. The Federal Rules of Evidence do provide a framework for most states' local rules on what evidence is heard. The goals of the Federal Rules of Evidence are so that relevant evidence is heard by the court, so that the judicial process is efficient, and so that the process is fair to the parties. Important to this is hearing relevant evidence. And relevant evidence is defined as any evidence that has the tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. If you have a motor vehicle collision that takes place on First Avenue and Main Street, it's going to be relevant what color the traffic light was, whether there was a traffic light, what parties were at that intersection. It's not going to be relevant what was happening 5 blocks over on 5th Street and Broadway. The court only wants to focus on things that are going to help the jury make a decision as to what the facts actually were. Now, even if evidence is relevant, the court may still exclude it. And the basis for this is that the probative value of the evidence, its ability to help the jury, is going to be outweighed by another factor. These factors under Rule 403 are unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly cumulative evidence. Let's tackle each of these things in 3 different parts. Unfair prejudice and confusing the jury. In this case, this is because the court does not want evidence to come in that's going to allow the jury to make a decision, not based on what the actual facts are, but to be swayed by how they may feel about those facts. A common scenario could be, and actually an actual case out of Alabama, Carter versus Haynes in 2018. There was a motor vehicle collision. One driver rear-ended the other. The court was asked whether or not to allow evidence of the at-fault driver's drug use. He took drugs, smoked marijuana, 6 to 7 hours before that accident occurred. The court looked at that evidence. The defendant smoked marijuana 6 to 7 hours before this accident happened. Should the jury be aware of that fact? Should evidence be put forth? And in this case, the court said no. And the reasoning was because there was no evidence at the time of the collision by any witnesses on scene that the defendant was impaired or unable to operate a vehicle or otherwise under the influence of any drugs or alcohol. The court said that just because the defendant had smoked marijuana 6 to 7 hours before, that was going to be unfairly persuasive to the jury. The jury might find him at fault for the loss, not because he was at fault, but because they have an animus towards that drug use or want to punish him for the drug use. If there had been evidence that the defendant had been impaired, certainly the court then would have allowed the evidence to come in to show the defendant's impairment. However, without other evidence of impairment, the court thought that that evidence of drug use was going to be biased and too prejudicial against the defendant, and so they did not allow it. The other issue that comes up frequently is confusing the issues. Let's take another scenario where you have a homeowner, they purchase a dishwasher. They purchase it from a national appliance company, but hire a local company to come in and install it. 3 weeks later, after it's installed, of course it starts leaking, because that's why we see subrogation cases. You have a claim against the installer for negligent installation, but also potentially against the manufacturer on a product defect case. You file suit against both of them, and as you go through the process, the manufacturer comes forward and gives you a 50% settlement offer. Now you analyze the entire case and you think, I do want to take this 50% before I go forward with the risk of trial, but I'm still going to go forward against the installer after I settle. The court is more than likely not going to allow evidence in the case against the installer that you've already settled with the manufacturer. It's too confusing and it's not clear to the jury why you settled, and they may use that information improperly to come to an unfair conclusion. So information as to settlements with other parties is very unlikely to come before the jury because it's just too confusing. The jury is going to maybe make improper conclusions about that fact, and therefore the court does not want them to have that information. Finally, undue delay, wasting time, or unduly cumulative. This is all about judicial efficiency. Certainly, parties want to put forward the evidence they need to carry the burden of proof. And if you have questions on what the burden of proof is, check out the On Subrogation video specifically focused on that topic. Now, let's say you have a motor vehicle collision and there are 12 witnesses. You have your driver, you have the defendant, and you have 10 other people who were there at the intersection and saw what happened. If you put forward one person who says the red car ran the red light and hit the blue car, and you put a second witness on who says the red car ran the red light and hit the blue car, and then you put a third and a fourth and a fifth, you can see where this goes. The court isn't going to require every single person who can testify to that fact. They're going to allow a party to put forth enough evidence, but especially if the other party is not disputing it, the judge is not going to allow witness after witness to testify to the same thing, especially if it's an undisputed fact. Parties certainly have the ability to put forth their case and have their case heard, but the court also needs to make sure that cases are moving quickly. A motor vehicle collision does not need to turn into a 3-month trial as witness after witness puts forward the same testimony on the same undisputed facts. For On Subrogation, I'm Jason Sullivan. This has been our video on federal rules of evidence and specifically relevant evidence, and in which cases relevant evidence may still be excluded by the court. If you have a video topic idea, please email us at video@rathbonegroup.com. We hope you enjoyed this video, and for On Subrogation, that's the long and short of it.